Welcome to Rocinio Law. Here's your host, Albert Rocinio.
We're going to discuss today about wills, living wills, and powers of attorney. Mostly, I'm addressing, New Jersey law, but it's really a generic issue and applies wherever you live. Everyone should have a will. There's really not a good reason not to have a will. If you have children, you most definitely need a will. If you have assets, you most definitely need a will. You want to direct who is going to handle those assets when you pass away, and you want to direct where those assets are going to go. These are no small considerations. If you really want to do your family and or friends, anyone, a service, make the preparations, do a will. This way, when you pass, your financial situation is organized. They'll know who's handling it, and they'll know what they're supposed to do, because that's what a will does. So let's talk about a few things relating to wills. Why do you need a will? You need a will because if you die what's called intestate, which means without a will, then you have to go through intestate succession. Most states have laws. We do have those in New Jersey. But you don't get to select who's going to get what monies. It goes by a rate. It goes by a chart that determines where your surviving relatives are on the chart. So if you die and you have children, your children or your wife, they would inherit first. If you're married a second time, you have issues between your second wife and your children from your first marriage. You don't want to have that. The intestate succession laws might not be what you want and will not accomplish what you want. By having your own will, you can direct who is to get what money and who is to handle the money. Very important. If you have children, you have to ask yourself, or you're going to be leaving maybe money to somebody else's children or minors, they inherit. If you have grandchildren, do I need what's called a testamentary trust? That's a trust where the money is going to be held for the benefit of the beneficiary, and that trust is created within the will. It's called a last will and testament. So it is a testamentary trust. Talking about those things is very important because you're going to want to appoint the trustees who are going to handle the money until the beneficiaries attain a certain age. Most of the trusts that we have are available for the health, education, and welfare of the beneficiary. So if they were minors and they needed money for school, tuition, food and clothing, shelter, medical needs, the trust could always be invaded by the trustee for those purposes. Otherwise, a lot of times the distributions are discretionary. Sometimes they can be mandatory, like you could have in a trust that every quarter all the income needed to be distributed. But if you don't have that, then the income can be reinvested, causing the trust to grow, which is a good thing. So there's lots of issues. If you're married and you're of a higher net worth, you may use a marital deduction trust or a credit shelter trust in your will in order to direct your assets between the spouses to maximize the amount of tax-free money that you can move. So just very simply, without getting too technical, federally speaking, you can transfer right now, it's actually a little over, but we're going to use an easy number, $5 million tax-free per person. What does that mean? That means you can transfer $5 million to anybody you want using the unified credit, and it's tax-free. There's no federal estate tax. If you're married, that means, and you plan properly, that means you and your wife could move up to $10 million tax-free if you know what you're doing. If you don't plan right, hypothetically, you have a $10 million estate and you die and it all goes to your wife, and maybe half of it was yours, $5 million, and half will be attributed to her, $5 million. And now she has a $10 million estate. She dies, and that money gets distributed out. $5 million of her estate will be tax-free, but $5 million of her estate will be taxed by the federal government. Unfairly, many would say yes, because it's money which for most people has already been taxed at least once or twice, taxed when you earned it, taxed when you earned like a dividend or an interest on it, but it's also taxed when you die and it passes. If you estate plan properly, you die, you have a marital deduction trust or a unified credit shelter trust, you put your $5 million in that. It's for maybe your wife's benefit, but now it doesn't go to her estate. She dies, she can transfer her $5 million tax-free. Both of you have transferred $5 million tax-free, and that now estate has no tax. So you need to really go to a professional, somebody like me, who knows what they're doing. I've been doing this work for 33 years. I started as a tax attorney. And going to the proper professional who knows the questions to ask, knows what to do, can make a big difference. They'll talk to you about things like special needs trusts. Those are trusts which are totally discretionary. They're good for people that may be on governmental assistance because many governmental programs like Medicaid have very, very, very low limits for the amount of assets you can have and the amount of monthly income you can have. And if you exceed those, you'll get bumped. So you need to really know these things. You need to plan properly in doing your will. Additionally, you may want specific bequests, and they could be to individuals or entities. There could be to some charitable contributions. What's the difference between leaving a specific bequest of $5,000 to your church versus leaving 5% of your residual estate to your church? Is there a difference? Yeah, there's a difference, and it can be a big difference, not just financially, but in how the estate has to be administered, how complicated it is, the fact that now that you have a residuary beneficiary, that's a charitable organization, the Attorney General has to be brought in to review and approve your accounting to make sure that the charitable entity isn't being cheated. So these are all the types of things that you want to know. And quite frankly, and listen, I mean, everybody, you do what you want, but quite frankly, the websites that you can, purchase a will is, not usually the right way to go. And it's not going to address the things that you really want to address. That would be like purchasing a pair of pants that's one size fits all. Okay. It really doesn't work that way. We all know that. You have to buy pants that are your waist and your length. One size doesn't fit all. Wills are no different. The time and the money that you expend up front to do this right will benefit you and everybody that's relating to you and is involved in your will and your estate later on. The next document I wanted to talk to you about is called the Power of Attorney. That's a document whereby you appoint someone to handle your financial affairs while you're incapacitated. Somebody who deposit your checks and pay your bills. Make sure your homeowner's insurance is paid, your utilities are paid, your mortgage is paid, etc. Very important document. My opinion, no reason not to have it. Like an executor or a trustee, and it is a business position, so you want somebody trustworthy, somebody that's good with handling money. The difference between the executor and the power of attorney is the power of attorney will end automatically when you die. That's when the executor takes over. The executor is the person named in your will who's instructed on how to handle your final financial affairs, liquidate your estate, do the accounting, and pay your beneficiaries. So everybody should have a will. Everybody should have a power of attorney. There's no reason not to. The third document I want to talk to you about is a living will. And there's other documents that are out there, by the way, but I'm just going to talk to you about these three. And the way I do a living will is twofold. It's two parts. I do an advance directive for healthcare. That's where you are telling your doctors, in the event I am brain dead, permanently comatose, etc., I have a short time to live. I want you to withhold all extraordinary life support means. Basically, give me drugs, make me comfortable, let me go. And that's your right. And that one of those, in New Jersey was one of the states that led in that right. There's a case called In re Karen Ann Quinlan. People that are my age would remember her. She was a young woman from the 70s who overdosed on drugs. They intubated her. They kept her alive, which is what they were supposed to do, which is what all doctors and hospitals are supposed to do, unless you have a directive otherwise. Back then, there were no living wills. There were no directives. essentially what happened was her family wanted to remove her from life support. The doctors, the hospitals had a problem with that. They said they couldn't do that. And eventually that case worked its way up to the New Jersey Supreme Court, known as In re Karen Ann Quinlan. And basically what they said was, we're going to allow you to remove her from the intubation. You must maintain the fluids. You can't remove the feeding tubes and such. Because it was a novel case of first impression, and that going forward, at least in New Jersey, everybody would have this right. And consequently, if you don't exercise the right, then it's got to be presumed, and it should be presumed by any doctor or hospital, that you didn't want a living will. And then they should keep you alive no matter what. And it just interestingly, in the Karen Ann Quinlan matter, to my recollection, what happened was they removed the intubation, and her body now, but it took something like 10 years. Her body had adapted, and she continued to breathe on her own for a few more years, kept alive by the feeding tubes, until she eventually expired. So, if you want to control your last illness and you want to direct how it's going to be handled, then you want a living will. The second part of the living will is a durable healthcare power of attorney. This is how I do it. And that has basically the same language as the advance directive, where you're telling the world this is what you want to happen, and you're telling your doctors this is what you want to happen. But additionally, you're giving an individual the right to speak on your behalf when you can no longer speak for yourself. So you got to pick somebody that can do the job. Before, we were talking about powers of attorney, executors, trustees, business positions, handling money, trustworthy. Now we're talking about somebody that you trust and somebody that can essentially, quote unquote, pull the plug, right? Tough thing to do. If you've never been there, I have, and it's not a pleasant experience. So you got to select somebody that can do the job. Somebody that maybe will understand the medicine, and somebody that can simply do the job. And so, and in that form, we have HIPAA release language, because you all know that if you don't give HIPAA authorization, technically, then the doctors in the hospital could say, even though you're their authority to talk on their behalf, they didn't allow us through HIPAA laws to disclose their medical information to you, which would make it pretty hard to exercise their right to end-of-life choices. So with those three documents, a will, a living will, and a power of attorney, most people will have a basic but yet complete estate plan. And how complicated the will is, whether you need a testamentary trust of any type, whether you need a living trust of any type, and that's a discussion we can have another time, because there can be Medicaid planning issues, which are extremely important to people. Sometimes Medicaid planning is more important than actual estate planning. You'll be able to do that. Look, I've enjoyed this time. If you have any questions of a generic nature, I'd love to answer them for you. I can't and do not create any attorney-client relationship via the internet, YouTube, these videos. But I would love to have any of your comments or concerns. Love to have you like this video. Love to have you share this video with your friends. And please subscribe to my channel. Thank you very much.
Thank you for watching Resinio Law. Please do not forget to like and subscribe.